Right from Florida, Union State of Florida. Yo, this is a Q&A session with Ali Taj. Got me here live for about 30 minutes. Um, so you can always come right onto the live and hit me with some questions. I will do my best to answer them. Always remember the disclaimer. This is not to be construed as legal advice. Just my own personal, testimonies from things that I've experienced. Um, so yeah, let's see. As we're live right here on YouTube and Facebook. So hopefully people are up. Um, Hopefully they are not at service right now. A lot of people are observing their religious beliefs at this time. But if we got some people available that want to, actually, let me see. Just trying to fix the settings. I think that, okay, now so. Trying to play. All right, yeah. So you guys can comment on it. I can see your comments. Um, Interact with you. Like I said, usually I charge for consultations, but this is your chance right here. You got me live. Um, so all those who want to ask any questions you may have, of course, we won't call them legal questions, but any questions you might have on any various subjects or topics, just let me know. I'll be glad to answer them for you. And also when you're in the chats or you're commenting, just let me know what state and if you're in a different country, just let me know what country you're in. We'd love to see the different interactions and how far we are reaching. So far, no questions because I really didn't have a topic to discuss. So I really just came on to just to whatchamacallit, just for Q&A, just to interact with you guys, see what's going on with you for the 2-3. We are now in the 2-3, so hopefully, not so much about New Year's resolutions, but we should always want to wake up and be a better version of ourselves and add a better piece to ourselves daily. You should always work on yourself daily. You work on everything else. So it just makes sense to make sure that you're working on your executions. Make sure you're trying to eliminate any areas that are stagnant, that you procrastinate in. Just make a more conscious effort and a better intent to accomplish things, to write down your goals, to journal about it, so you can read back and review and see if you're hitting or making those goals on time. Um, a lot of things people don't understand, like a lot of planning goes into things. Life doesn't just happen. I mean, it does happen, but you should have an active part in participating in life. Um, and like I said, it's all about writing things down, researching things. A lot of us, we have questions. Um, and I think a lot of us out here and more people are learning is that, you know, there's an answer for every question. And it's just about a matter of where to look. And some of the first places to start with nowadays is just, pretty much go to Google. You have Bing, Yahoo search, all these different engines that will give you probably no less than a couple 100,000 hits. And from there, just go into information. And sometimes, depending on what information you're looking for, it will take you to a government site. A lot of times, it asks you to turn on your location, or it'll say searches near you. So you would always want to put that in if you're looking for a business or something like that. I see people make posts, hey, I need a good carpenter, or I need a good real estate agent, or different things of that matter. I mean, it is good to make those posts and find someone who might be local with you, or someone, depending on if it's a service based, and depending on what type of service, if it's something that could be done virtually, or no matter where they're at, they might be in a different country, they may be in a different state, different city, and they could help you with that and probably give you a reasonable or respectable price. You know, um, sometimes it's kind of hard to expect um, discounted services unless that person is actually running a discount or promotion at that time, and there's a coupon code or some type of deal they're willing, or a negotiation. Some people may be willing to barter for a service. They might have a need for something that you have to offer. So never be afraid to offer or extend your services in exchange. I mean, I wouldn't lead with that. I would just find out their prices, and then just kind of throw yourself out there as far as what you offer and what you bring to the table. And that person might actually be looking for that, or looking for someone to plug to their clients that they already have an existing clientele that might put you into just give you a whole new base of people to market your services to. Um, Click on them. So I don't know. This is my first time using this feature actually, but I'm waiting and looking for comments to appear that I could respond to. Um, so far nothing. And let's see some of the other features. All right. Um, yeah, just it's really not a lot of features. Different things. I think you can change some of the colors and different things. But I mean, I'm really trying to interact with everybody. I don't know if there's something that's blocking you from commenting or something like that. I'm just trying to figure out what's going on. That there's no comments appearing, because it might be something I need to tweak on my end. Because, like I said, I'm just kind of rambling, but I am looking for a topic to discuss that might help some people. Some people might be going through some cases right now, as far as legal cases, civil matters, foreclosures, things of that nature. Um, I do happen to have some experience, some court experience with different matters of that type. Um, and mostly the things that I come to find out, and it's just more about repetition and really understanding it and honing your craft. But when you get into these lawsuits, everything is like it says under the Constitution. No state shall make any law that is impairing the right to contracts. So you really need to look at that, or even search that through case law, because everything is founded on that contract. Everything that gets you in court is based off a contract that was signed and agreed to, whether it was a oral contract, are still enforceable in court as well. Um, and I think you just have to have some of the details of that. Witnesses are good, affidavits by witnesses, different things. Um, but yeah, oral contracts is just as good. Same as with a trust. A trust can be expressed orally. It can be expressed through publication. You can publish this in the newspaper. You can record it. It's just so many ways to express a trust. It doesn't always have to boil down to a trust instrument. Um, but yeah, most times I've seen cases that were litigated, and maybe someone, a credit card company, bought a lawsuit against you. A lot of times, and this is crazy, that we get those packets even when you open a bank account. They give you that big book, and it's got all the terms and agreements of the deposit accounts and different things, and um, things that it's on both sides. It's unilateral, not unilateral, bilateral obligations on both sides that you guys can enforce. And a lot of times when I first started researching, I always only looked to the statutes. And then as I progressed and started learning, I started understanding the statutes are cool. And a lot of times there's not a lot of remedy right in the statutes. There's sometimes you get lucky and right in the statute under certain subsections, it'll tell you that you can enforce your rights or that they can't do that unless you do this. Um, but then I got into rules of procedure. And you got to make sure, because I used to mess them up in the beginning too, even though they say it clearly. But when you're in civil matters, you're using the civil rules of procedure. And when you're in criminal, you're using the criminal rules of procedure. But most of your remedies are in the criminal rules of procedure. Then I got to another level where I started understanding when you file an answer to a complaint or you file a complaint and you don't use case law, they pretty much get to use the case law that they want that strikes down your argument, and you can lose just because you didn't use authoritative case law. So that was another level of understanding. Then the next level that I came to was that basically sometimes the people suing you are using certain provisions, articles, or clauses within your contract to win the suit. So it was layers. I started understanding it's really not one thing, or just because the law says this is that, you're ultimately enforcing the contract, which has to be introduced into the court. That's why in most states, I'm assuming, it's part of their statute or their rules of procedure that you must attach a copy of the evidence of indebtedness. So that way it can be enforced. So you can go ahead and get your mediation clauses right out of your contracts, whether it be your mortgage, your credit card. They all have them. They all have an arbitration agreement. So when they sue you, a lot of people panic. They get deer in the headlights. They don't know what to do. They don't know how to respond. They don't know the timeline. So usually what I do on the consult is I let people know, go right into your state's rules of civil procedure. And it's a timeline. It's just like reading a book that has an index in the front. And you can see where you're at. So the first thing that starts out is you will go file your complaint, and then you will have a copy of your summons filled out. The clerk will stamp your summons with the seal. She will give you an original one. And I think either a copy or you have to make a copy, depending on how many defendants you have to serve. But you will get, you probably will get an original seal for each defendant you have to serve. And then you will serve the complaint and the summons. If you're on the receiving end, if you're not the plaintiff and you're the defendant, you must be served by the plaintiff. And this is one of the ways I'm going to give you some sauce of avoiding a lawsuit is if they can't serve you, it goes to this saying, no face, no case. So if you make it hard to be served, the case can't proceed. And even if it did, because sometimes I'm quite sure some courts will proceed anyway and issue a default judgment on you, you can always come back at a later time and say, I never got served, or I never had knowledge of this lawsuit. So that undoes the default judgment. You have to file a motion to vacate, get that judgment undone. And then if you're prepared, now you actually have to, or if that entity files to bring the suit, chooses to bring the suit again, now you have to defend it. So again, in the rules of civil procedure, you're going to start with the complaint, starts with the summons. Then it's a time of response. And then there's discovery matters you can do. So it leads you down. Don't jump and skip. Just follow it. It's like a soundtrack to a movie, basically, is you can see where you're at and what you need. So if somebody filed a complaint, and then it'll say on the summons, it'll tell you you have 21 days to respond to this. If not, a default judgment will be entered against you. So now you will go and look to responses, pleadings, and affirmative defenses. And now defenses is basically the bullets to your gun. You can have a gun, there's no bullets in it. It doesn't protect you. So your affirmative defenses are like arrows in your quiver for your bow and arrow. Once you read them, you'll see what I mean. If you look in your, you can look in the federal one, look in the Uniform Commercial Code, and it will look up affirmative defense or defenses. And then it will name some, and then it'll say these are just some of them in addition to what it says in the state code or in the contract. So you would respond to that within the 21 days. You would cite affirmative defenses in the Civil Rules of Procedure. It tells you what you must do just to properly state a defense. And it says it must be pled specifically. It can't be general. It can't be, just based on conclusions. You got to be able to have at least some type of evidence to support the defense that you're making that you can attach as an exhibit to it. You also have to be careful of exhibits can be hearsay. So depending on the lawyer, he's going to probably move to strike it, or he's going to object to certain parts of your pleadings or attachments, exhibits as hearsay. So that's another part. It's usually it's in the Civil Rules of Procedure, but it's in a different section. So sometimes it's a separate book. It's called the Rules of Evidence. So when people say like how to get started, one of the things you want is get a hold of your Civil Rules of Procedure, get a hold of your Rules of Evidence, get a hold of your Criminal Rules of Procedure, and then there's another one called Judicial Administration something, Rules of Judicial Administration. There's a couple other ones because you want to know what your judges can do when they have the power to act and different things. So that's part of it as well. I learned this. But sometimes you can go right on Amazon and there's a book that will have all of this in it. It actually has rules of traffic court, it has the rules of family court, and you have all of it completely. Now, if you go to your law library, your local law library, which is sometimes in the courthouse, um, there are books. Trying to think which one. Sometimes it's the well, because sometimes I don't go to the books. Now it's all on Westlaw. So you go on Westlaw and you look, and it will say forms and something. So under that section, because I thought like lawyers are like just so smart and crafty how they drafted stuff, and most times it always looks like a template. Um, in Westlaw's database, where it's under forms, it'll give you a general outline of how the form looks with the caption and everything. So you can literally copy paste that, or you can take it and retype it into Word or whatever you're using to format, and then go ahead and add your facts in and everything, and then save this as a template. So it's not that hard. Like people are like, I don't know where to start or how to do it. The other thing is the rules of civil procedure under pleadings tells you what's required for that state and that requirement to avoid a default, not a default, a motion to dismiss, which is, and I think in most jurisdictions, it's called a be either B6 or B12 or something like that motion, which is a motion to dismiss. And they can do that based off procedural errors. So let's say if you did respond. So if you did respond, you wouldn't get a default judgment. They would move to dismiss based off of your procedural errors or something you didn't plead properly. So once you could defend these, and even in foreclosures and bankruptcies, people don't know that a lot of times while you're losing and losing your home or whatever, is either you're not showing up, you're not responding to the pleadings, the list pendants or the complaint that's filed after that. Um, and what you should be responding, and I've heard people say this in response, it's the same thing, but they say that people aren't filing counterclaims. Counterclaims almost takes on the form of a separate suit. It's a suit outside of the one that's pending. Um, that it can be considered by the judge because now he's weighing both sides. But if you never show up, you never file, then all he'll tell you right in his opinion that a review of the record and the affidavits and everything submitted, that these were my findings of fact, because everything has to be findings of fact. There's findings of fact and there's findings of law. So if you look in your affirmative defenses, you can actually win a foreclosure. And a foreclosure is a very stressful process, but it's a beautiful thing if you come in and you could break down and attack certain things in their filings. So now you get them against the wall. Once you get them against the wall, you want a motion for a summary judgment. And if there's no more material facts of dispute, you can have your motion for summary judgment granted, which would undo the foreclosure and actually force them to remove the lien. There will be a judicial, not judicial, but there's a judgment by the court that is a summary judgment in your favor, and then there's a final judgment. The final judgment is appealable. The summary judgment is not. So these are just some facts. I gave you some juicy stuff. Like I said, this is stuff that typically most people will contact me for consultations for. But even though, I mean, you still can contact me because this is just like an overview. Some people still might not understand it, or, most people will say, and there's no disrespect to them, but they might need you to baby it down, put it in layman terms for them. And that's where a one-on-one is like priceless. You get a one-on-one with me, you get my mind in the moment, and I'm thinking and I'm strategizing. I'm almost like a coach on a basketball team or a football team, and I'm really just strategizing, seeing how I can come up with a win for you. Because wins are important. I want you to think, I know there's people out here that are just about taking your money. But for me, if you take 1, 2 to 10 people's money, and now you get this reputation out there that, he didn't do what he said, or I don't think he was as thorough, or I think maybe he's just repeating someone else's information because he doesn't seem like he has actual experience and testimonies of his own. So my pride is on trying to come through and get wins for people, because wins you can brag about. Even if you lose in litigation, it's still not over. You have appeals, you have post-conviction relief motions that you can file after the fact. You can vacate judgments if they're void, if there was surprise, if excusable neglect, like your house caught on fire or it was flooded and you weren't staying at that address and you didn't get certain filings or something like that. That's excusable neglect. Clerical mistakes, those things could be changed later. It's almost like having an eraser on your hand. At any time, you can get a hold of different things and change the outcomes. So it's never over, and it's over. Like if I helped you and we didn't succeed on the first try, and you're like, oh man, don't like this guy, we lost. All right, it's not the end of the world. We can keep going on. So these are just some of the things I want you to understand, and I'm giving you a chance to give you an introduction to let you see that I have a great understanding, a great deal of understanding, and probably have, it's going on like probably 30 years of legal experience, and I'm talking about being in the courts, and it's crazy how over the years it changed. But yeah, going in bright, bushy-eyed, being 18 years old or 20 or something, standing before a judge is very intimidating. Even if you're 30 something, if you've just never been in a court, it's very intimidating until through repetition you start to build up, because you have to get in a place of you have to be comfortable. You have to be very comfortable. It's hard because they're there to make you uncomfortable. They will threaten you. They will cite wrong law and tell you that well, you filed that, but it doesn't matter, or something like that. They're going to do a lot of things to you. They're going to try to anger you, frustrate you, make you forget. Because if you're on a train of mind and you're flowing, they'll disrupt you and say something, or Sometimes they'll say, we need to take a recess, or I have another call coming up, or I got a Zoom, and we'll come back, and so on. So they do all these things and tricks, and or do a continuation. Like if you're winning and you're getting the best of them, they'll do a continuation and get you back in another month or so. And it kind of changes things. You start to become a little, what's the word? Like you get a little discouraged. And then sometimes you're at the point where some people are ready to just tap out. They're like, you know what? I'm tired of this. Got to keep coming to court. It's stressful. I'm just going to da 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 da. And they're counting on that. One of the things I want you to know is that coming into the court as what is called a pro se litigant, you are probably one of the most hated uh, creatures on the face of the earth. Uh, I never understood that. Being young, I was like, all right, she knows I'm this age, or because of my background, demographic, where I come from, I can't afford a lawyer. I had never probably met a lawyer, growing up. My number one in my family just had lawyers on retainer, or just like, hey, just call John, see what John thinks. Like, didn't come from that. Um, so yeah, it was crazy. But let's see, we did about almost a half hour. And again, like I said, I don't know. I'm asking you guys, are the comments working? Are you allowed to comment? Because there's no comments here. So like I said, I wanted to respond and help you guys out. But I think I gave you a lot of helpful, useful information that you guys can use. And again, after this live is over, if you could, you know, subscribe, share, like, comment, ring the bell on YouTube, and just let me know what you think about the live. Appreciate you guys. Thanks.